Let's see, what do I do here? All right, let's not do that. Give me 1 second, guys. All right, so as a lawyer, I should start with some disclaimers. This presentation is not intended to be legal advice, and none of my opinions expressed today are those of any of my employers, Great Rivers Environmental Law Center, Menees, and Wynee, and/or St. Louis University. With those legal disclaimers out of the way, I will talk to you today about using advocacy as a way to promote good planning. So what's the plan, Stan, for today? Here's a brief overview of some of the topics I'll be talking about. We're going to cover a lot of ground, and hopefully your brain will feel well exercised at the end of this endeavor rather than bored, but I can make no guarantees. So let's start way back, and let's talk a little bit about the history of planning and zoning, so we can kind of bring some old stuff forward and talk about where we're at. So before zoning and planning, lots of land use disputes existed. People had to use the common law to address conflicting uses of law, namely theory of nuisance and the theory of trespass. So basically went down this: you are using your property in a way that is unreasonably interfering with my enjoyment and use of my property, or you're spewing things onto my property, invading my property, and I'm going to sue you. These theories and legal causes of actions became woefully inadequate to deal with land use disputes in the face of rapid urbanization. They may have worked pretty well in England and colonial times, but as urbanization happened, they became pretty inadequate. And so local legislatures started to pass zoning laws and regulations. You're probably aware of the seminal case of Ambler Properties versus the City of Euclid in 1926, where the Supreme Court basically said that a legislature has the authority to promote the health, safety, and welfare of its people through land use regulations, so long as those regulations are not clearly arbitrary or unreasonable. And with this 1926 pronouncement, the Supreme Court of the United States blessed the separation of property based on uses and set the stage for the wave of Euclidean zoning across the country. That's happened ever since. And so here on the slide, in 1920, after this seminal Supreme Court case, the federal government, through the Department of Commerce, through the Hoover Commission, put together these two model statutes, the Standard Zoning Enabling Act and the Standard City Planning Enabling Act. I think it's somewhat ironic that what has become a locally dominated theme was in large part instigated at the federal level. Also interesting how little the federal government has played in some of these issues since. So these two acts, the SZEA and the SPEA, then after put out or adopted widely across the country. Almost 100 years later, most state statutes haven't deviated much from these two statutes. Some states have. They've taken significant steps to reform their planning legislation from these starting points to ensure plan implementation. Others have used updated statutes to adapt to the evolution of planning ideas and modern problems. But most, and you guessed it, Missouri, are still deeply entrenched in these roots and have not deviated much from them. The original idea was to separate zoning, which was supposed to be a legislative and a political function, from planning, an administrative and apolitical function. In reality, these lines have become blurred by various factors like councils, stacking commissions, developers, or other lobbyists influencing commissioners, and a lack of public involvement in the process. But this was the original idea. Planning and zoning would work together to address these land use conflicts. Here's, before the Hoover Commission came out, you could see the city of St. Louis was already engaging in some rudimentary zoning. There may have been an earlier version. Someone could correct me at the end if I'm wrong. This is a map from 1925. There might have been a map from 1921. But you can really see that this is just a zoning map from a zoning commission. It looks pretty rudimentary, but a lot of places haven't come very far from this humble beginning. Fun aside, this is a large life-size printout from the Civil Courts building in the Law Library. They got a lot of gems as it relates to old planning and zoning documents there. I tried to take pictures of these in some research I was doing to follow a property as to how it had been zoned since the beginning. Anyway, fun aside. So from the standard Zoning Enabling Act, the standard City Planning Enabling Act, we get these adopted in Missouri. They are the state statutes that provide authority for counties and cities, towns, and villages to engage in planning and zoning. These are the statutes that lawyers spend most of their time in if working with municipalities or counties. What's important here is that counties and cities have only those authorities delegated to them by the state through statutes or the Constitution. And so we'll talk about that here in a little bit. Here's Missouri's enabling statute for cities and towns, stemming from the SZEA. Lawyers spend a lot of time comparing these state statutes to local ordinances and zoning decisions like findings of fact and conclusions of law from BOZA hearings. Here's Missouri's enabling statute for cities and towns, stemming from the standard city planning enabling. The take home from these is that ordinances can supplement and flesh out these laws, but they cannot conflict with them. So if the state law under this planning provision says you need to give 15 days notice of any planning commission meeting to adopt a plan, a local government could not by ordinance say we're only going to give 10, but they could say we're going to give 30. The bigger issue that arises from these statutes is whether ordinances that are passed pursuant to the powers granted in these state statutes are authorized by the state statute, or whether the ordinances or regulations are what's called ultramarines or without authority. So other than statutes, local governments can derive powers and authority to plan and zone from Missouri's Constitution. There's a provision in the state's constitution related to charter counties. Some of you may work in these charter counties, and these counties have a broader authority than non-charter counties and cities and towns and villages. They basically have the authority to address distinctly local concerns. Planning and zoning has been held to be a distinctly local concern. In fact, I think the most recent constitution is from 1970 and it uses this language, but earlier versions of the Constitution talked specifically about planning and zoning and being an authority or that a charter county would have under this section. And that notion was subsumed into this language of distinctly local concern. And so there's really no question at this point that that language encompasses the authority to plan and zone. So charter counties can supersede supersede the state authorities in the state statutes, which gives them a broader planning and zoning authority than non-charter counties. One note of significance is that charter or home rule cities are not blessed with that same authority. They're still bound to follow Chapter 89, the planning and zoning statutes for cities and towns. There's an interesting wrinkle there where Section 19 of the same article of the Constitution vests the police power of charter or home rule counties with a broad police power authority. But as it relates to whether something is a police power regulation or ordinance, or whether it's a land use or planning ordinance, courts have held that Chapter 89 is the enabling statute that even charter cities have to follow, and they cannot deviate from that state statute. So if we look a little bit deeper into the authority to plan, we see Section 89.340 RISMO. It says the commission shall adopt a plan for the physical development of municipality. Also talks about that such plan may include other things, location, character, utilities, things like this. And so it's pretty close to what the Standard City Planning Enabling Act talked about. The Standard City Planning Enabling Act required a plan to include these among other things. Missouri, when it adopted the SCPEA, decided to make these considerations merely discretionary as opposed to mandatory. So when you look at the SCPEA in Section 6, footnote 35, it defines what among other things could be. And it says the enumeration of the kinds of matters with which a city plan should deal, which follows these words, is purely illustrative and in no sense meant to be exclusive. But then it goes on and really just kind of focuses on physical elements and physical characteristics. So then the question arises in a municipality's authority to plan whether they can plan for other issues, not just physical elements. And so some of the more modern issues that we deal with now that weren't necessarily on people's radars 100 years ago are things like affordable housing, inclusionary zoning, sustainability, climate change, things like this. And the million-dollar question is, do these municipalities have the authority to plan for these type of issues? When you look at the state statute, you see that one of the purposes of planning is to promote the general welfare and efficiency and economy in the process of development. Maybe we can look at some of those issues under this rubric, but I guess the question then becomes, how do we look at those issues solely through the lens of physical characteristics or elements? So then when we talk about the authority to zone in the state of Missouri, and I apologize to people in Illinois. I did not know I was giving a presentation to people in Illinois. Otherwise, I would have included some Illinois stuff. So you're going to have to hear a lot about me beating Missouri over the head, and maybe Illinois has some of the same problems. Anyway, the powers of a municipal legislative body to engage in zoning regulations and ordinances, same concept, to promote the health, safety, and welfare. But when you look at these elements of what you can zone for, it really also seems singularly focused on physical characteristics and uses. When we look at the next section, the purpose of the regulations shall be designed to lessen congestion, provide adequate light and air, a lot of other a lot of other stuff that seems also pretty focused on physical elements and physical characteristics. There is this bolded language in there talking about other public requirements, maybe some of those other concepts like affordable housing or inclusionary zoning could be shoehorned into this language. Nobody's ever pushed the envelope. A court's never really ruled on that issue. And then we get to this doozy. So what's the purpose of zoning regulations? Well, the first thing it says is that it's to achieve the goals of the plan, right? Such regulations shall be made in accordance with a comprehensive plan. Makes sense that after such efforts go into planning, that those recommendations would be followed by the legislature in their zoning regulations and decisions, but guess what? That's wrong. And so what we have are some different ways that courts across the country in dealing with this provision, as most states adopted the SZEA and SCPEA. This language appears in almost every state statute, and different states have dealt with the issue differently. And these three basic ways go from the comprehensive plan, the master plan, whatever you want to call it, having the least weight or legal authority to the most. So you have the unitary approach where zoning ordinances and a zoning map is a plan. You have planning factor approach where the comprehensive plan is an important factor in a zoning decision, but it doesn't control it. It's not dispositive. And then there's planning mandate states that require substantial compliance, and you would need to show the court a substantial justification for why you were deviating from the plan in order for that not to be deemed to be not in accordance with the master plan and therefore illegal. So what's going on in Missouri? Where does Missouri fall? In 1994, there was a case called Chiavala versus Oakwood. You had Oakwood, this teeny tiny town outside of Kansas City, and they passed one zoning ordinance that said all property in Oakwood will be single family residential. And obviously somebody challenged that, claiming that how could one zone pass the zoning regulation for single family only in accordance with a master plan when there's no plan. And the court held that a comprehensive plan may be validly enacted in an ordinance itself without existing in some form separate from the ordinance. Since there is evidence that planning was done and there is no specific requirement that the village pass a separate comprehensive plan as a condition precedent to the passage of the zoning ordinances, we find that the single family only ordinance is both constitutionally and statutorily valid. So Missouri is one of the jurisdictions that subscribes to the unitary approach in finding that you really don't even need a plan in the state of Missouri, even though there is a state statute that says you have to make a plan. Apparently you don't have to make a plan, and you don't have to zone in accordance with the master plan because you don't even need a plan. So what's the rub here? Unless you're in a planning mandate state, you probably shouldn't be hoping that your great planning efforts are followed by local legislatures or upheld by courts. Courts rarely overturn zoning decisions that are not in conformance with a plan. This leads to erosion of good planning based on political zoning, things like that. But if you look at it from another angle, courts even more rarely overturn zoning decisions that are in conformance with a plan. And so what this does is it creates an added layer of deference that can be used to convince local legislature to make decisions that promote good planning. In Missouri, some cases say that public benefit factors that have been used by municipalities to deny or uphold deny rezoning requests or to grant rezoning requests that have been upheld by reviewing courts include things like a municipality's wish to avoid piecemeal zoning, a cohesive, well-maintained nature of a neighborhood, reliance on studies or plans by a municipality, things like that. The concern philosophically, when you think about this dichotomy between planning and zoning and where things were originally with this political process versus this administrative process, the concern is that zoning becomes an administrative function rather than a legislative function. But I think everyone on this call, for the most part, is a planner and probably would like to see their planning efforts have more weight of law than this sad picture that I'm painting. So we have this planning and zoning dichotomy. In Missouri, you don't even got a plan, you got a zone, but you don't got a zone to the plan. And so we have this politically motivated zoning process, this administrative planning process. We have planning laws that limit consideration in plans to physical elements. We have zoning laws that are 100 years old that promote Euclidean zoning, that deal with physical elements and that can just push aside good planning efforts. And so we end up with this dichotomy where we have planners thinking in the future and having these great ideas and you're all whiz bangs and we look up to you. And then you got the law, which is this terrible old beast with its wheels stuck in the mud. So in my environmental background, there's an ecologist named E.O. Wilson, and he's famous originally for studying ants and things like that. But he wrote a book called Consilience, and the main thesis in that book was that the medical field, physics, biology, chemistry, they've all managed to speak a similar language, and that kind of speaking of a similar language has allowed that field of study to really progress quickly and efficiently. And other social sciences all have unique vocabularies and have difficult talking to each other and have a harder time at progressing quickly. And so clearly planners and lawyers speak different languages. I teach a class where I teach both, and it's pretty fun to watch the big disparity between certain knowledge of certain topics and the way people talk about things. And so the question becomes, can these gaps be bridged? I'll come back to this here in a little bit. So some of the problems that arise from this dichotomy, I'm not going to read them all, but I guess you guys are all familiar with these. We could talk about these for an entire hour, which I won't do. And I'm sure you guys could add many things to this list that isn't on there, but I'll just leave it at that. So what's the plan stand really? Plan is not law. Zoning regulations are the law. So how do we establish and defend good planning against the problem? And I'm a lawyer, and so we advocate. And what do we advocate? I'm not going to tell you yet. So let's take a step back and look at what it means to be an advocate. So I'm a lawyer. I have to look at my ethical obligations. One of the foundational roles of an attorney is to be an advocate. But what does that mean? I've bolded the take-home message here. It's that I'm supposed to zealously represent somebody. And the notion in the legal community and the rule of law is that if I represent someone zealously and someone else says someone zealously representing them, then justice is done. I'd say that you'd kind of have to be a moron to think that equation or that recipe works for justice. If you have more money to pay for better zealous representation, you're probably always going to win. So justice is almost never done. Fortunately, in my role as an environmental public interest nonprofit lawyer, I oftentimes get to zealously advocate for my clients in the public interest. And so I can pay more attention in my role as an attorney to this other concept of being a public citizen and seeking improvement of the law and reform of the law. But advocating for changes in the law and advocating for anything other than your client's desire gets a little tough for most lawyers. So you guys on this call, I think pretty much all of you being here are probably members of the APA or the AICP, and you guys have your own code of ethics. Public interest as opposed to zealous advocacy seems to be the dominant theme here. You're supposed to have consistency with client and public interest. If they're plainly inconsistent, you have to act in the public interest. That's entirely antithetical to my code. I have to act in my client's best interest no matter what, at all costs, unless they're violating the law or something like that, or lying, something like that. Your guys' code of ethics seems way greater than ours. So what are you supposed to do as an advocate? I think that both of our codes of ethics make clear that we are supposed to be advocating for something. What can we be advocating for? So here's some ideas that I'll be talking about going forward. Advocating for doing more than state law minimum, if that's still what the law is, and using ethical obligations as support. Trying to engage in using progressive zoning tools, using this notion of legal deference as support to try to push some of those concepts forwards, and then finally advocating for better laws to expand planning and zoning authorities to deal with issues that didn't exist 100 years ago when these outdated laws were passed. So going to this first issue about advocating for doing more than your state law minimum and using your ethical obligations to support this task. Here's your ethics code. You're supposed to provide timely, adequate, clear, and accurate information to people. You're supposed to give them the opportunity to have meaningful impact. But at the same time, the state law for municipalities, for planning meetings and for adopting plans is to just have one meeting, give 15 days notice, and publish it in a newspaper that nobody reads. And so there seems to be a pretty big conflict there between what the state law says and what your ethical obligations require you to do. And so you can advocate for your local municipalities. Like I said, you can't do less than what the state law is requiring, but you can advocate for more. And so if you're in a municipality that just kind of copied the state law into their ordinances, you could advocate for there being more public notice, more meetings, things like that in your municipality. So why are zoning tools important? According to Molly Just, a senior planner for WSB, here are some reasons why zoning is essential to meeting planning goals. I think one of them here is, you've gone through all this effort and time and expense to plan, and then the first time a zoning decision comes up after you've done that plan, it asks to deviate from the plan and the local legislature caves. That doesn't seem like a great outcome of a lengthy and costly planning process. So just keeping in mind who the different zoning stakeholders are. There's a lot of them. I think that, as planners, you're trying to achieve your plan goals, but that doesn't necessarily always happen in reality. And there's a lot of interest trying to get things and use land in ways that might go against those goals. And so what can you do to try to avoid that? So going back to zoning law, here's a doozy case where our environmental law center tried to challenge a rezoning decision and did not succeed. But here's the standard with which courts look at these zoning tools: is we may reverse regulation or ordinance only if it's arbitrary and unreasonable, not fairly debatable, and has no substantial relationship to the health, safety, morals, or general welfare, and the evidence is viewed in the light most favorable to the government's decision. So this is in the law, this is as deferential of a standard as exists. And so the question is, or the thought is, if this deference is here, how can you use progressive zoning tools to advocate for them to your local legislatures to make sure that good planning results or good zoning decisions happen to promote the good planning that has happened. So you always have to go back to kind of what are the authorities. And so cities and counties with only statutory authority have to ask whether they've been delegated this power and whether what they're trying to do is arbitrary and unreasonable. Counties more latitude to be creative, but neither can pass zoning regulations that go too far and constitute a regulatory taking of property without just compensation. That's a topic in and of itself that I won't talk anymore about. I'm happy to come back and talk about that issue with you guys at a later date. But we're just going to be talking about authority for this presentation. So I did a little survey. You guys probably think overlay districts are old hat and not a progressive zoning tool. Maybe you think they're okay, they're good, whatever. So in my search for overlay districts on LexisNexis, a legal research tool that I have, I found 264 different overlays in the state of Missouri. There's a ton of jurisdictions that aren't linked up to LexisNexis. So my guess is that that number is significantly larger than 264. They address, as I look through them, all sorts of different things: scenic overlay corridors, environmental corridors, historic corridors, things like that. So since everybody's doing this, there's so many of them, it's got to be kosher, right? Well, go to a different search function with the same search term in Missouri, and you find that there are 3 cases in the state of Missouri that have ever used the word overlay district. And I will tell you that 2 of them in no way, shape, or form address whether an overlay district is a permissible zoning tool. There is one case from Kansas City that finds that an overlay district is illegal. They say that it's defective on its face because it conflicted with other zoning provisions and was vague because it used terms like rural, rustic, and non-urban. Last time I checked, I thought the purpose of an overlay zone was to be more restrictive than an underlying zone, and so there were inevitably going to be conflicts. So the one Missouri case that's addressed an argument that an overlay district is not permissible has found that it's not permissible. Not good news for all of the people out there who have overlay districts. What about another zoning tool? Transit-oriented development. Can municipalities under their statutory authorities engage in this type of endeavor? Maybe not. There's no cases in Missouri where somebody's challenged this, but when you look at the purposes of the zoning regulations, it's to avoid undue concentrations of populations. And so if avoiding concentration of population is the purpose, is there an argument that somebody could try to challenge this and say, you're trying to concentrate populations and so you don't have the authority to do that? Perhaps. I guess what I'm getting at with some of these tools is the laws that give the power to engage in this type of stuff aren't abundantly clear about how far that power extends. And so a lot of jurisdictions are kind of out there in no man's land and are possibly subject to some legal challenges in using what they would be arguing is their implied authority to engage in this type of zoning activity. So concluding on zoning tools, there's lots of deference, but there's also a lot of uncertainty. And I can't really give a one size fits all on how far a certain local government can go in utilizing these tools. But I think it's a fair statement that given the amount of deference afforded to zoning decisions, planners can advocate for the use of these tools to implement plan goals to their legislative bodies. There is a lot of uncertainty unless you're in a charter county with your own zoning authority. And even then you start talking about regional issues, whether you have the power to deal with those, because that constitutional authority only applies to distinctly local concerns. And so if you're doing TOD, is that something that's infringing on some regional, more than local transportation issue? And do you have the authority to do that? I don't know if that answer is clear. So if as a planner, you're not comfortable with this type of advocacy, kind of advocating for going out into the fringe of authorities to try to defend good planning through progressive zoning tools, you can advocate for better laws. And so here's what I'm supposed to do. And I guess by you guys having me here today to talk about these issues, you're helping me meet my ethical obligations. So I appreciate you listening to me pontificate about these issues as I meet my ethical obligations to try to advocate for people to seek improvement of the law and employ that knowledge in reform of the law. You guys are supposed to seek social justice. You're supposed to recognize disadvantaged communities, promote racial and economic integration, and you are supposed to urge, aka advocate, for the alteration of policies, aka the law. So you're ethically obligated to be advocating for better laws. And what can you be doing in that regard? What are the options out there? So here's some things to think about. We can advocate for laws that provide express authority for progressive zoning and planning. We can advocate for legislation to help implement planning. We can advocate for regional legislation to combat localism. And we can advocate for environmental justice and advocacy planning, which I'll get back to in a minute. So express authority statutes. Some states have decided that this notion of an implied authority and what a local government can do is too unclear. And so Massachusetts in 2004 passed an express statutory authority for its local governments to engage in smart growth overlay zones. And so you can see, if you compare this language to kind of the SZEA or SCPEA language about the purposes of the regulations, you can see that this language starts to address more specifically issues that weren't necessarily recognized. They were probably around, but not as recognized as being valid pursuits for local governments to pursue. They start to get out of this rubric of physical characteristics. So unless you're in a charter county, there's a fair amount of uncertainty in the extent of authority under Missouri's enabling statutes about the ability to do something like smart growth. And so these types of express authority statutes would provide certainty to engage in these types of zoning techniques that kind of gets rid of that uncertainty that I talked about a moment ago, and kind of having to have the municipality stick their neck out and hoping that they're not going to get sued, and that a court would find that they have this authority under this very deferential standard. One of the concerns with these express authority statutes is the notion that, well, this implied power provides so much deference that we can kind of as a local government, make these choices ourselves? And what if our state government passes a law that's really restrictive and it makes it so that then we're stuck with this express authority and it's too limiting and it's not as effective. And had that not been there, we would have been able to maybe use our implied authorities in a way that was more suited to us. I mean, that concern is out there, but I'd say that the getting rid of the lack of certainty would aid municipal bodies trying to engage in these types of techniques more so. So some other types of express authority statutes that are popping up around the country: inclusionary zoning, affordable housing, things like that. This notion of trying to get away from physical elements and focus more on social justice. These are the types of things that we as lawyers, you as planners, can try to advocate for in trying to kind of bring an evolution and upgrade of the laws that bind us. So legislation to implement planning, going back to some of those concepts we talked about earlier. The APA Smart Growth Manual has some good discussion on these types of issues of, in Missouri, planning is, I don't even know what to call it. It's courts have no respect for it. And I feel like you guys should be advocating for there to be more respect for what you do. I appreciate what you do. I know other people appreciate what you do, but apparently if your legislature doesn't appreciate what you do, courts aren't going to appreciate what you do. So that's kind of bogus. So maybe one of the options is to advocate for Missouri going in more of a direction of something like a planning mandate statute, and what that looks like. It can just be incentive based. It could be sanction based. The incentive based would be that if you engage in planning and you follow the planning, you can do things that you weren't already authorized to do, like impact fees. Planning with sanctions would kind of be more of the stick versus the carrot, where if a government didn't exercise regulatory and related powers for planning, and if they hadn't adopted a comprehensive plan that satisfies statutory criteria, they would not have the authority to zone. So you take away their zoning power if they don't follow the plan. And then the smart growth manual kind of has this aspirational notion, which I guess has been somewhat achieved in a couple states around the country, is this completely integrated planning system that looks something like this. It would be legislation that mandates a state, regional, local planning system that is integrated both vertically and horizontally. Vertical consistency is the concept that regional and local plans be consistent with state plans and vice versa. Horizontal consistency calls for neighboring local governments to ensure that their plans do not conflict with one another. And from this different array of choices, there can be a balance struck between local self-determination and increasing state and regional involvement. So how do you go about advocating for that? The APA recommends some of these options. I look at them and I see how none of these, except for maybe one, is anywhere in the remotely possible in the near future. I don't think there's much Jeff City, Missouri legislative support or gubernatorial support for these types of actions. And so one of the suggestions is this notion of a private coalition or consensus building where there's little or mixed support in the legislature or by governor. I think that's the shoe that fits the audience and the jurisdiction that I'm talking about. And so, it's pointed out here that private groups like the APA, yourselves, Chapters may join with others in the hope of getting agreement on the elements of a bill that could then be introduced by a supportive state legislature. Apparently in 1991 in Kansas, the Kansas APA chapter, the Kansas League of Municipalities, the State Home Builders Association, the Kansas Association of Counties, and some other groups successfully obtained enactment of major amendments to the state's planning statutes. So that's probably the biggest advocacy that could be proposed, and the feasibility of it is probably not great, but you got to start somewhere, right? So maybe the ask is for something less big and something more like regional legislation. Florida engages in some regional planning where there's these different regional planning councils. Missouri has this huge rural and urban divide. And so while a statewide planning mandate statute might not be possible, perhaps something that addresses kind of an urban planning versus a rural planning is something that's more feasible. Here in Missouri, in the urban areas, the suburban areas, we have issues related to sprawl, which is a regional issue. You could try to do something related to that at a regional level. There's issues with floodplain management in more suburban, urban areas. I guess rural jurisdictions also contribute to that problem, but maybe that is a goal for statewide planning legislation. But with these, the issue really comes down to, is a top-down or bottom-up approach better? I think as our world becomes more interconnected, I think it would be crazy to think that local authorities can truly address some of these bigger picture issues in and of themselves when the person right next to them is doing something totally different. That's just a picture of Florida's regional council. You can see that it, breaks the state up into different areas based on kind of unique resources and differences, maybe in culture and what's there. So when I was preparing for this, I named my presentation because I wanted to talk about advocacy work. And then I came upon this notion of advocacy planning, which apparently is required reading for everyone I'm speaking to. And so you must all know about this. I didn't know about it, didn't come across it in teaching my land use class until preparing for this presentation. So it's new to me, but I was really shocked with the parallels between this planning school of thought and issues that I've been running into in my environmental law practice. And so advocacy planning has been around since 1965. Environmental justice has been around arguably as long, or kind of after civil rights movement into the environmental movement in the 1970s. And so just going back to that concept of, apparently planners have been thinking about these issues for a long time and it hasn't really gotten us there. Environmental advocates have been thinking about some of these issues and haven't really gotten there yet. And so Tom Angotti of Progressive Planning, which I guess is the outgrowth of the older group of advocacy planning, he says there would be no environmental justice movement if the traditional environmental organizations had incorporated social justice into their missions, just as there would be no progressive planning movement if the establishment planning organizations truly became advocates for social justice. Like planners, the mainstream environmental groups deal with environmental issues as strictly in the public interest. And so this is something that our nonprofit organization has struggled with over the years. How do we look at environmental issues more through a social justice lens when we've been trained to look at these issues in a more traditional way, just looking at the environment? Sounds pretty analogous to this notion of physical characteristics and planning versus looking at some of these other broader social justice impacts. I think both professions are in some senses ethically obligated to be thinking about these things. So the euphemism of only as strong as the weakest link comes to mind. And if planning, zoning, and the law aren't prioritizing the most vulnerable people and communities, there really isn't an appropriate advocacy for what's in the public interest. I think that's what advocacy planning is talking about is like what really is in the public interest and how do we get there. I think that your guys' ethic code provides a nice map to advocate for that type of direction in the planning community. So in the environmental justice field right now, we're seeing an entire proliferation of environmental justice legislation at the federal level, at state levels, and at local levels. Cori Bush has put forth an environmental justice bill that kind of starts the way of trying to gather data for to try to then make further steps to promote environmental justice, and saying we really haven't been looking at these issues in the way we should, and we need more data, and we need to figure out why some communities are getting the brunt of some of these environmental impacts. And so perhaps this kind of watershed moment that we're talking about these is a good opportunity for areas that have kind of been stuck in these 100-year-old zoning and planning regimes legally to try to push the envelope forward. So I found this Tishman report that's from 2019, and there was a regional survey done on how planning and zoning tools were used across the country to combat environmental justice. And the study found these kind of 6 categories of tools that are being used across the country to try to address environmental justice. Bans, environmental justice policies. One of them is proactive planning, health codes, things like that. And the report found here's where these things are happening. Clearly, we see it's not happening in Missouri. But St. Louis and Kansas City are both established urban areas that can follow suit of some of these other areas in starting to look at these things. But then it always goes back to the question of, do these jurisdictions have the authority to engage in these types of practices? Is there separate legislation that needs to be passed? I think that with these efforts to pass environmental justice statutes, there's room for passing updated zoning authorities and planning authorities that allow, explicitly allow municipalities to engage in these types of activities. Here's just a list. If you want to look this Tishman report up, you can see here's some of the proactive planning. Lots of it are overlay zones and green zones and things like that. But I didn't have enough time to really delve into these things, but just as a resource for you guys. So what's the plan? Stan Redux, Stan Marsh of South Park. He's depicted as logical, brave, patient, and sensitive. He's outspoken in expressing his views about injustices in South Park. I'm not advising that you all go gung-ho or rogue and lose your jobs in the process of trying to advocate for these things. But I think unless advocacy is a major part of the toolkit, not much is going to change. That's still why we have laws from 100 years ago in planning and zoning. It's why we have environmental laws that really haven't progressed much since the 1970s. Missouri seems particularly stuck in the mud compared to other parts of the country. Everyone wants the St. Louis region to reclaim its former glory. But unless we advocate for some of these changes and address these issues, we probably won't get there. So hopefully that gives you a nice primer of thinking about some of these things big picture. And I'd be interested to hear any suggestions you all have and some of the things you've come across in your practices that might fit well into this rubric that I've been talking about today.
Thank you, Bob, very much.
For questions.
Yes, we have plenty of time for questions. So if anybody wants to put their questions into the chat, I will read those out to the group.
No questions. It's like the last semester I taught where everyone's in the black screen. We used to laugh when we would teach class and people would hide behind their computers when you'd look to ask questions. Now people just mark off their screen.
All right, we have our first question. Thank you, Susan. Since St. Louis City is its own county, does it have the broader authorities you mentioned for counties?
Yes, it does. It is considered a charter county for those purposes, and it does have the ability to operate outside of Chapter 64. I think the concern I raised there is at what point is what the city trying to do hit a point that it's not dealing with a distinctly local concern. There was a case not that long ago in the Missouri Supreme Court where the city tried to do something related to like mortgages, and the Missouri Supreme Court said that's more of a statewide issue. And so the ordinance that you've tried to pass to regulate mortgages you don't have that authority because it's not a distinctly local concern. And so while the traditional notion of planning and zoning is considered a distinctly local concern, when you start thinking about a more regional issues, it begs the question of whether that same authority would extend that far.
Hey, thank you. Next up, in your research, did you find other communities doing form-based zoning as overlay districts?
Other communities outside of the city of I'm aware that the city of St. Louis has some form-based code in some neighborhoods, and I assume that there are a lot more across the country. There's some places in Texas and California. So yes, they're doing it, and then you have to go to that state and say, what is the authority that's allowing these jurisdictions to do that? Are they kind of stepping out into this implied authority area, or are they operating under an express provision that authorizes them to do it?
All right. Who are the progressive state legislators besides Cori Bush?
That's a pretty political question. I don't know if I want to categorize people as something. I know that she has put forth some environmental justice bills at the federal level. At the state level, I don't have a good grasp. I try to bury my head in the sand on some of those issues because they're so depressing as to what's coming out of Jefferson City, especially as it relates to environmental issues. It's crazy. Right now, the Missouri legislature apparently is trying to get rid of the emissions inspection program for St. Charles, which is in a non-attainment zone for ozone. And they're basically trying to play chicken, pun intended, with the federal government over highway funds and are risking $52 million of highway funds. So there's a lot of non-progressive things going on in Jefferson City, and I don't have a great grasp of all the players who are doing good things. Maybe you can direct me in their direction and I can give them advice from behind the scenes, which does happen sometimes. I see another one.
Yes, so this one's a longer question. With many cities commissioning various analyses and studies related to planning and land use, what is your opinion on whether these would be required to be considered part of the community's comprehensive plan? Alternatively, is there an ability for communities to implement and reference these specialized plans without officially making them part of the comprehensive plan?
I mean, in Missouri, you don't even have to have a comprehensive plan, and you don't really have to zone in accordance with it. And so the question becomes, they're out there, and I had mentioned that case where Missouri courts had upheld factors in denying a rezoning request of studies that a municipality, they had done some studies and they used that as the reasoning for not approving a certain zoning decision, and the courts deferred to that pretty heavily. And so I'd say that trying to get back to the question, I don't think that they would necessarily have to be part of a comprehensive plan or like incorporated into it for a municipality to rely on it. Maybe there would be more deference if it was specifically incorporated into it. Going back to that one slide, it's, courts, if courts in Missouri don't overturn legislative decisions that aren't in accordance with the comprehensive plan, but they basically will never overturn one that is, unless there's like a taking or something like that, then it might be better to have those studies form part of the comprehensive plan. And then, yeah, I know Jonathan's the one who is asking me this question, and I don't know if he's specifically asking about a specific provision that I'm aware of in the jurisdiction he works in, where a zoning ordinance incorporates a plan. And there's some interesting legal issues that arise from making your regulations, which have to be amended in a certain way, to be
Bob,
based on.
I wasn't trying to trick you. I'm sorry.
Right. Well, to be based on plans that can be changed without going through that same process, right? So if you have a zoning regulation that says, here's the uses, here's what's allowed, but then you hinge that to something that can be changed outside of the legislative process, it raises some questions about the legality of that.
Sure. No, I can appreciate that. And I'll pop on just so I wasn't trying to veil a question or anything. And no, I appreciate the feedback. That's what I was like. And a broader topic, we have been pushing in Kirkwood various sub-studies and analyses and things from a planning perspective. That seems like a good idea, but we haven't always necessarily full circle made them adopted parts of our comprehensive plan. So I was just curious on your point of that. And no, I'm sorry, I wasn't specifically referencing the legislation.
I think you'd get more deference if it was, but that
Sure.
There's pretty good case law that says that any studies that are relied on, even if it's not the comprehensive plan, provide some rational basis that is pretty impossible to overturn in court. It doesn't mean somebody's not going to challenge it. It gives some assurance, push word to come to shove, then it would be upheld.
Sure. I appreciate that very much.
Thanks.
All right, we had another comment posted into the chat. A zoning stakeholder missing from your list is bankers and lenders. They can use zoning to influence development in ways that counter what we are trying to plan for. They also sometimes do things like enforce their own parking requirements regardless of the local zoning. So many other things too. Any comments to that?
Yeah, that's unfortunate that somebody has that much control over land use decisions and or just the way things unfold under land use plan regimes. I will add them to my slide for the next time I give this presentation, if I ever did. I will. And I don't know how you bring that to bear. There is some case law about the effect that local governments cannot contract or give away their governmental functions, like their legislative functions. And so maybe a creative lawyer use this concern that you're raising and try to challenge some of these practices as being a kind of a location or infringing on governmental function. I don't know. I'd have to think deeply about the viability of such a legal claim, but it's interesting. And I think that those environmental justice pools that report calls out are specifically passed in response to some redlining practices and different kind of institutional racist practices in citing decisions and things like that. So maybe there's a coordination of those types of efforts for justice purposes with some of the problems you're identifying in not promoting social justice.
All right, thank you. Follow-up comment. I'm hearing that developers trying to build transit-oriented development are being required to put more parking in than the city or developer wants. The lenders are wanting more parking than the developer. Yeah. All right, guys, do we have any more questions for Bob? One new message. All right, what are most of the planning zoning court cases in Missouri about, and how many planning zoning lawsuits are brought every year?
I not answer the second question. There's definitely a couple big ones going on at all times. There's been, rise and fall in it. They mostly happen, I say, over either reasons granting of variances or let me step back. Granting or denying a rezoning, granting or denying a variance, or granting or denying a like a special use or a conditional use permit. Those seem to be the main go to the courts. I wouldn't. There's not huge body of law of people challenging plan stuff, because as we just talked about, the plan doesn't have the effect of law. I mean, so unless there are violations of the state law in like not providing notice and things like that, and then a plan being passed, those don't come up nearly as much as challenges to those decisions.
All right, thank you. We'll hang on a few more moments here for any last minute questions. While we do, I will mention to everybody that you should hold your calendar. Our next luncheon will be on June 16th. So we'll have some more information coming out about that shortly. Additionally, we will have an announcement somewhat soon about a social this summer. I know we've all missed each other. So keep your ears out for that. Hopefully we'll have some more information soon. And as I don't see any more questions coming into the chat, I think we can wrap up. I'm sure that Bob would be happy if you had any other questions, you could reach out to him. We can put you in touch. So yeah, thank you everybody, and enjoy the rest of your Wednesday.
Thanks.